Afternoon, Alan and Tebuho.
Afternoon, sir. We only have you and Miss Mabi later in the meeting, sir, at the moment.
And Mr.
And myself.
Oh, yes, and
also in the
Mr.
platform.
Vessels, sorry.
So we are three. We are running short of three.
Yes, sir.
Their apologies.
I haven't received any apologies at the moment, up to now, sir.
Okay. We'll wait for other members to connect so that we can start with the meeting. Honorable Dr. George and Honorable Maviletsa, can you try members of your parties if they can't join us to form a quorum?
Will
Okay,
do,
I'll do
Chair.
that. Okay, I'll do that.
Okay, okay. Thanks. I see Honorable Sarupen is here. Thanks, Honorable George, for getting your colleague. Tebu, we're running short of one person, one member.
Yes, sir.
Yeah, I think I see Dr. George has tried to get us Honorable Sarupen. Thanks, Dr. George. Honorable Mavileza, are we succeeding with the ANC?
Yes, Skosana is going to log in now, and Murolong said I should send an SMS.
Okay.
Okay.
Chair, I've just let Mr. Skosana in, so it's 6 members.
Oh, Skazana has joined now. Oh yeah, Kijiman Skasani. Okay, yeah. Honorable Mavila, Honorable Sarupan. Yeah, we are 6. Okay, thanks very much, Dr. George and Honorable Mavilet, for getting your colleagues to join. Now we form a quorum. Welcome, honorable members. Welcome officials from Treasury. Welcome stakeholders. Welcome the parliamentary staff, the support team to the SCOF, and welcome the public at large and the media. The meeting is officially open. Are there apologies? Alan Temuho?
I didn't receive any apologies up to now.
Chair, from my side either, no apologies.
No apologies. Temuho, that problem of technology of network has started again. Just find a better spot where you are so that you can have a better network. No apologies so far. Let's move to item 3, response by National Treasury on the public hearing submissions. Who's taking a lead from Treasury? Cindy, I see you are in the platform. Who's leading the Treasury team?
From the chair, it seems to be, it's going to be Janine and Vukile from Treasury that will lead the team, honorable members. Thanks. And Janine has been made co-host, so she will write her the matrix. Thanks.
Janine, where are you?
Good afternoon, Honorable Chair. Are you able to hear?
Yes, we can hear you.
Okay, thank you very much. And good afternoon, Honorable Chair, and to the members. And thank you very much this afternoon for the opportunity to present our response to the comments received on the Financial Sector Laws Amendment Bill. And I'm Janine Bednar-Guillothe. I'm with the Legislation Unit in the National Treasury, and I'll be sort of leading the presentation in conjunction with some of the other colleagues from the National Treasury, Vukile Davidson and Ero Makobela and Langalise Nkabinde. And then we also have some colleagues from the South African Reserve Bank, Sabia Mohammed, Jacques Boutas, and others. And they will also come in on responding to some of the comments, particularly some of the more detailed and substantive comments on the bill. So just to start off, we've circulated 4 documents this afternoon to the committee. We've circulated a response matrix, which is what we'll first focus on and look through. And then we have a couple of other small amendments that we would like to propose to the bill to address a couple of technical aspects that we identified with the bill that it would be helpful to ensure are clarified in the finalized bill. And then we've also provided the proposed amendments that we are suggesting in our presentation today, we've included them as a list of amendments, which could be included in the A list for the committee's deliberations. And so we've circulated that document, as well as a version of the bill that indicates the proposed amendments as track changes on the bill, so that members can see how the amendments would be included in the bill, the proposed amendments. So before we start, does the chair or any of the committee members have any questions?
No question, Janine. You
Okay.
can proceed
Thank
with
you.
the responses.
And just one thing we would like to note, there was one submission that we received early this afternoon, just before the meeting here, that we had not received, seemingly not received previously, from the South African Institute of Stockbrokers. That submission does not appear to be substantial, and it doesn't seem to raise serious issues, but we have not been able to include that in our submission this afternoon, but we could perhaps undertake to look at the submission and then provide feedback on that if there is any significant comment to provide on that submission in our next meeting. And we apologize that we were not able to include this submission in our comments matrix this afternoon. So we would just want to note that for the committee, just so that it's clear we did not we didn't intentionally not include a response to one of the comments, because we certainly want to clearly respond to all of the comments. So in just a moment, let me just share the screen here. Are the members able to see the screen?
Yes, we can see the screen. Proceed.
Okay, thank you very much. So the first amendment was proposed by BASA, and it particularly relates to a concern that they have regarding a current provision that exists in the Insolvency Act and the impacts of one of the amendments in the bill that might have on the status of that existing provision in the Insolvency Act. And they were recommending that this particular provision, as it stands in the Insolvency Act, should be preserved. And so I wonder if perhaps either Jacques Boutes from the SARB or Langelihle could come in and speak on this amendment, please.
Good afternoon, Honourable Chair. Thank you, Janine. Good afternoon, honourable members. Chair, this section relates to the protection of collateral that was posted for certain transactions. So when the banks enter with the counterparties in these transactions, they post collateral for these transactions. And under Section 8310 of the Insolvency Act, when a bank is placed into liquidation, the third party is then able to realize that collateral in protection of that transaction. So BASA made some comments on that they would still want this protection under the new framework, and we've set out quite a detailed response to the issues raised by BASA. Firstly, just to state that this protection will continue. Resolution will not remove that. If a bank is placed in liquidation, the counterparty will still have the rights under Section 8310. And then just perhaps to go a bit further into a little bit more detail, as we set out in our response, the purpose of a resolution is to continue, is to continue with the operations of a banking entity. And therefore, we do not make provisions when a bank enters resolution for the counterparties to close out those agreements and to realize that collateral. The bank will still need to continue performing on its obligations in terms of those agreements, and therefore those agreements should not close out and that collateral not be realized. And that's what we've captured in our response, and that's in line with international standards. That's in line with the aim and objectives of the proposals of the bill, and therefore we don't see that it requires any amendments to how the bill is currently drafted. Thank you, Janine.
Thank you very much, Jacques. Sorry, I'm just having a slight problem with the screen here, just for a moment. So the next two comments are from BASA, the Banking Association of South Africa, and they have noted that currently in the Insurance Act and in the Financial Markets Act, the definition of the Financial Sector Regulation Act does not include the full reference to the Act number and year, as would normally be the case in relation to how acts are referred to in legislation, in the definitions in legislation. Now, these definitions and other definitions that were inserted into the various financial sector laws by the Financial Sector Regulation Act, when Parliament was processing the Financial Sector Regulation Act, they could not include the Act number of the Act because at that stage there wasn't an Act number that had been assigned, because that's only provided once the President has assented to the legislation. And so that is why the final version of the Financial Sector Regulation Act did not include the full reference to these pieces of legislation. And so in response to these queries, we would propose that we will include an amendment in a forthcoming Financial Sector Laws General Amendment Bill, which we're developing, that would amend the definitions in all of the various financial sector laws in an efficient and clear manner, and address the definition in all of the relevant legislation. This would avoid trying to address in this legislation matters which, strictly speaking, aren't part of the original amendments that were proposed in the legislation, and committees do have some restrictions on the extent to which they're allowed, in terms of the rules of Parliament, to consider approving and recommending additional amendments to bills that are before them that are outside the scope of the bill as originally tabled. So we would recommend addressing those references through the subsequent legislation, which will be tabled shortly. And we appreciate that that has been highlighted to us in the comments, and we will certainly ensure that that is addressed. The next comment from BASA is in relation to Clause 1, and in terms of, it's again recommended that in respect of the Insolvency Act, it's recommended that we insert a definition in the Insolvency Act referring to the Financial Sector Regulation Act. And it's also indicated that there's the manner in this Clause 1 of the bill in which the Financial Sector Regulation Act is referred to is not consistent, because in one instance it's the full reference to the Act, and in the second instance it's a partial reference to the Act and the year. So in response to this, we would indicate that the full referencing used in the particular clause is correct, and it is consistent with how referencing is used in the Insolvency Act itself. And we would also note, in respect to potentially including a new definition in the Insolvency Act, that because that this provision is amending a piece of legislation of the Department of Justice that falls under the auspices of the Department of Justice and Constitutional Development and is not under the auspices of the Minister of Finance, we had to obtain consent of the Department of Justice regarding including the amendments to the Insolvency Act in the bill. And also Cabinet approved that approach when the bill was submitted to Cabinet. And so we're very reluctant to seek to add additional amendments into the Insolvency Act, which legally speaking are not specifically necessary, and we have not had an opportunity to engage on this proposed additional insertion of a definition in the Insolvency Act. So our recommendation is that we would just not make any amendments to Clause 1, and because there isn't any lack of legal clarity, and the clause as it's drafted is not necessarily incorrect from a drafting perspective. So we would just propose to leave Clause 1 in its current form as it was tabled in the tabled bill. And similarly, in respect of Clause 3, it again makes reference to that is proposed to include definitions of both the Financial Sector Regulation Act and the Financial Markets Act in the definitions of the Insolvency Act. And so again, we would recommend that it's not included, that the amendments are not agreed as proposed. We don't think that it's legally necessary, and for the reasons stated previously, we would propose not to undertake any amendments to that clause. In relation to Clause 6, it's proposed that in addition to Section 5(1)(c) of the Banks Act, that also it would be appropriate to delete Section 5(1)(d), which also refers to curatorship, and the amendment, the existing amendment is removing a reference to the curatorship process in relation to banks. And so we would agree with that proposal. And in the list of amendments, we've indicated that the amendment would indicate that Section 5(1)(c) and D would be deleted from Section 51 of the Banks Act. And then in Clause 8, in respect of Clause 8, BASA has proposed that some wording be added because the term financial sector regulator, which is used in that clause, is not a term that's defined in the Banks Act. And so we would propose, as indicated in the right-hand column, to add wording to the clause that would say, as defined in Section 1(1) of the Financial Sector Regulation Act. So that would indicate where the term is defined in legislation. Now, the next clause from Betweenity, it relates to Competition Act submissions that were made in the last meeting. And I don't know if Jacques or Lange would like to come in and speak on this aspect relating to the Competition Act.
Thank you, Janine. Happy to come in on this. Yeah, so we appreciate the comments that were made by Betweenity and recognize some of the important issues that they pointed out. I think as background, it's important to note that during the consultation period for the bill and in drafting the clauses, various consultations were held with the Department of Trade and Industry as well as Competition, and there was agreement that the clause should make provision for consultation with the Competition Commission when certain actions are taken in a resolution, and that has been provided for in the bill. Going beyond that and allowing a review of any actions that led to a merger during a resolution will curtail the objectives of the Act in allowing certain things to be overturned. And we see that as going against the purpose of a resolution. So we think it's not a workable proposal to have that review. And bearing that in mind, we should take into account that it's only for the duration of the resolution that certain other authorities' standards and rules do not apply to the institution. As soon as the resolution comes to an end and the institution exits resolutions, those provisions of the various legislation, including the Competition Act, will again apply to the institution, and the institution will again have to comply with those requirements. So for the duration of the resolution, it is only for the duration of resolution that those powers are excluded. So we believe that including the proposed section, that the amendments that Betweenity proposed will make it difficult to achieve the objectives of the Act, and therefore we have not, Treasury has decided not to include those amendments to the bill. Thanks, Janine.
Thank you very much. And then the next comment from BASA, they're recommending that in respect of in relation to some amendments to the Companies Act, which have been proposed, that it would be appropriate to define the Financial Sector Regulation Act under definitions in the Companies Act. And because we've inserted a reference to the Financial Sector Regulation Act in the various amendments that are proposed to the Companies Act. And similar to what we've proposed in relation to the Insolvency Act, again, in this situation, with the amendments to the Companies Act, we did have to engage with the Department of Trade, Industry and Competition and the Competition Commission in relation to amendments that we've been proposing to the Companies Act. And Cabinet again also granted approval for the amendments. And we specifically developed the amendments to minimize the extent of amendments that had to be made to the Companies Act. And so again, we would propose not to make any insertion of a new definition into the Companies Act, as the clauses as they currently provide are legally correct and they are sufficiently clear. And so we think, and we haven't had an opportunity to engage with the Department of Trade, Industry and Competition or the Competition Commission regarding any other amendment to the Companies Act. So again, we would propose not to make any amendments to insert a new definition in the Companies Act. In relation to Clause 32, BASA has proposed, because the term designated institution that's used in that clause doesn't refer to where the term is defined, and there isn't a definition in the Act that provides for a definition of the term designated institution. And so we've agreed with that proposal, and we would propose in the amendment to Clause 32 that's proposed to insert the wording as defined in Section 1.1 of the Financial Sector Regulation Act 2017. In respect of Clause 33, has been suggested by BASA that the new subsection 60, subsection 5 would appear to be unnecessary, considering that the existing section 60, subsection 1 and the new section 166D of the Financial Sector Regulation Act, which provides that a cancellation of a license can only be can only happen in concurrence with the Reserve Bank. And they recommended the deletion of the new proposed section 60 subsection 5. And Jacques, I don't know if you would like to come in just to explain the necessity of retaining that of the provision that we've included.
Thanks, Janine. The current Financial Sector Regulation Act in Section 31 does provide for the concurrence from the Reserve Bank on certain matters related to systemically important financial institutions. However, when it comes to designated institutions that extend, institutions extend beyond just financial institutions. And therefore, it was important to also include a provision that specifically relates to designated institutions and certain actions requiring the oversight of the resolution authority. We have, however, made a recommendation to delete sub D or sub 5. Sorry, Janine, if you can just move up. I just lost the number now. Yeah, sub 5. So we do recommend that that not be deleted, and that is necessary to keep in there for the purposes that I just mentioned, so that the Reserve Bank, when it comes to a designated institution in resolution, does have that overview of those actions. Thank you.
Thank you very much. And then in relation to clause 34, this is another similar proposal as in respect of clause 33. So again, we've agreed with this proposal, and we've proposed to insert the additional wording in clause 34 that provides as defined in section 1.1 of the Financial Sector Regulation Act. In respect of clause 35, it was proposed by BASA that the definition of agreement should be limited to being a written agreement. And they queried, how can terms of an agreement be proved if they're not in writing? And in terms of legal status, agreements do not necessarily have to be in writing, except in certain specified circumstances. And we included a broad definition of agreement so as not to inadvertently exclude some type of agreement that might perhaps not fall strictly within the scope of what would be termed in writing. For example, perhaps if there was an electronic transaction and instructions are sent electronically, is that properly considered to be concluded, an agreement concluded in writing, or is it concluded in an electronic form and there isn't any written form for the instruction? So we didn't want to unnecessarily exclude that definition. And so we would propose not to amend the definition of agreement, but to retain that as it is in the tabled version of the bill. And then in relation to clause 51 in the new proposed section 166D, 1I and J, it was highlighted that terms in the Companies Act, which are defined as amalgamation or merger and compromise arrangement, should be aligned to be defined as they are in the Companies Act. And so we've agreed with that proposal, and we've proposed the insertion of appropriate references in relation to amalgamation or merger as defined in section 1 of the Companies Act, and compromise arrangement as defined, as referred to in section 155 of the Companies Act. And then in respect of clause 51, in respect of section 166S2B, it was noted that there are references to arrangement, while the Companies Act refers to scheme of arrangement. And so it was proposed that perhaps there should be an alignment with that terminology, and we agreed with that proposal. And so we've proposed amendments to enable, to ensure that the references to arrangement refer to scheme of arrangement. And we've also proposed a couple of other related grammatical and terminology corrections in line to ensure that the provisions are in line with the terms as they're defined and referred to in the Companies Act. So all of the amendments that are proposed in relation to section 166S relate to these comments. And again, the subsequent comments here are similar comments in that regard. And then finally, there's an important comment from COSATU regarding the creditor hierarchy, and that it's desired that, you know, workers' interests should be appropriately given appropriate precedence in the creditor hierarchy. And so Jacques, would you like to come in, please, and provide comments on that proposal by COSATU?
Thank you, Janine. I think I'll make a brief overview statement of the response, and then perhaps Sabia, Mohammed, or Hendrik now can then also come in if they want something, have something to add. So we appreciated the comments raised and concerns raised by COSATU. We agree that there are certain vulnerable groups that require additional protection when dealing with banks, and from the bill, that is exactly the purpose by introducing the preferred ranking for covered depositors above unsecured creditors. So when a bank does go into resolution, it will follow one of two approaches. A bank will either be an open bank resolution, and in an open bank resolution, the bank will continue to operate. Depositors will continue to have access to their deposits. The bank will continue as normally, apart from the resolution actions that will be taken. And in that instance, we do not see these groups being affected. When the other route is taken, where in the resolution a decision is taken to close the bank, the deposit insurance will come into play, and these covered depositors will be paid out from the deposit insurance scheme. So those covered depositors will not have to wait for the liquidation to be finalized and for the estate to be wound up before they receive payment of their claims. It is then important to note these two separate processes. First of all, the liquidation as we know it currently, if a bank is placed into liquidation and those depositors have to wait for their money, versus what the bill is trying to introduce, this deposit insurance scheme where these covered depositors are paid within a certain period. At the moment, the deposit insurance scheme is working towards having a payout of 20 days within which those covered depositors will be paid out. Further work is being done to shorten those timelines, and in as far practical, the aim would be eventually to have that within 7 days. So these vulnerable depositors will not have to wait for the winding up of the estate, and they will immediately have access or access within that period stated to their depositors. And we believe that therefore the aims that the bill has is aligned to the concern that COSATU raised, that these groups should have access to the funds. And we've set that out in a little bit more detail in the response in the document. So an additional point I'd like to make is to take note that the bill doesn't introduce a creditor hierarchy. The bill simply proposes some amendments to the current existing creditor hierarchy in the Insolvency Act. And these proposals include then a ranking above unsecured creditors for those covered depositors, which will include vulnerable depositors, which we think, along with the deposit insurance fund, aims to achieve the protection of those vulnerable groups of depositors. Thank you, Janine. Sabia or Hendrik, I don't know if you want to add.
Janine, I don't think there's anything to add. Nothing further from me. Thank you.
Okay, thank you very much. So I think that this concludes the responses to the specific comments that were made on the bill. There is one other comment, but that was received that hasn't been included, but we will send through an updated version. We don't have a really substantive, doesn't raise substantive issues. And so we will just send through an updated version of the document that does include a written response on that particular comment. So I'll stop sharing this screen, and then we can perhaps, if members and the chair have any comments on the proposed revisions, and then there are couple of other minor proposed revisions that we would propose that are to the bill. And if members don't have any questions, I will put up that document, and then perhaps Sabia Mohammed from the Reserve Bank could perhaps just briefly speak on these proposed amendments. So are there any questions on the proposed revisions that we've discussed so far?
Proceed to make the presentation so that when members
Okay.
come at item 4, there will be reacting to what you have presented so far in regard to responses, and those whether are amendments or I'm not sure what you call them. It looks like it's a new information that you want to bring in.
So I'm just making sure that I put up the correct document. Apologies here.
Janine, are you still there?
Yes, my apologies. I think I've got the right document now coming up.
Okay.
Okay, thank you. Apologies for that. Yes. So we have 3 proposed amendments to add to the bill. And Sabia, would you mind please coming in to speak on these?
Sure, thank you, Janine. So I'm Sabia Mohammed. I'm the policy manager for the Corporation for Deposit Insurance, and I'll take you through these changes, and our interim CEO, Dr. Hendrik, now may add if I leave anything important out. The first change is to clause 35. In terms of the current wording of the FISLAB, or the Financial Sector Laws Amendment Bill, the membership will be a bank as defined in the Banks Act, a mutual bank, as well as a cooperative bank. We would like to change the definition just to explicitly include a branch, as you can see in the proposed amendment under B. And this is basically just to align with the guidance of the International Association of Deposit Insurers core principles of effective deposit insurance systems that specifies that all deposit-taking institutions need to be members of the deposit insurance scheme. So if we make this amendment, we just explicitly include the local branches of foreign banks as members of CODI. And this has been part of our consultation since 2020, so they are aware of this change. The second change is related to clause 166BA. In terms of the current wording, the financial sector regulators will issue standards and directives to promote awareness, and that will be to assist CODI. We would like to amend this clause to include the financial sector regulators issuing standards, directives, to assist CODI not only with promoting awareness among the customers, but also for other areas of functioning, such as the coverage that we will provide, as well as information banks need to submit to us. So it's just extending the areas that they can issue these standards and directives for CODI for. Oh, sorry, Janine, I think I skipped one. The one that, yeah, that's the last one on the list. So that one is just to make sure that we can issue all of these standards and directives through using the financial sector regulators, and that it won't only be focused on the public awareness directives. If we then go to 166BH, it currently states that the corporation must pay interest to members on the amount referred to in subsection 1, which interest must be specified in the standard. We would like to change that to specify that instead of on the full amount referred to in subsection 1, the corporation will only pay interest to members on the invested portion of the amount. The funding model that we currently have was a concession to be more cost effective for the banks. But in terms of the current wording, CODI would have to pay interest to the members on the full amount that they will place with CODI. So if we use any of those funds for payout, we would still have to pay them interest on the full amount, which will be significant cost to CODI. And we may even have to use our own funds to be able to pay members that amount of interest. So the amendment is basically there just to help us to protect our own funds and to pay the members only for the portion that has been invested. Yes, I don't know if there's any questions about these proposed amendments.
Are you done with the proposed amendments?
Yes, there's only the 3.
So by the time the drafters drafted this bill, they were not aware of these issues that you are raising now, because they were not there when the bill was published for public comments.
These are minor issues that we, for example, if we look at the definition of banks, we were under the impression that banks included the local branches of banks. The other 2 are minor refinements, which we only discovered later as we were working on the implementation of the different aspects of CODI's functioning. So we are currently looking at the funding model and how we can best implement that in a cost-effective manner for banks. And that is why we discovered the issue relating to the investment of funds. If we look at the financial sector regulation, the regulators issuing the directives, it was, I would almost say, an oversight, because there are so many areas of CODI's functioning that would have to be specified in standards and directives. So this is just a correction, essentially.
Okay. In the future, you should be thorough when you draft a bill, because government has got so many law drafters, so that when you deal with issues, by the time you publish a bill for public hearing, you should have dealt with the definitions and other substantive issues. It's an appeal because you have got all the capacity. It's unlike a private member's bill, but even with the private member's bill, they get assistance from the parliamentary legal team. So I think next time, do your homework so that you don't come with afterthoughts that this is what we forgot. And it's unexpected from a government department like Treasury to do that. Are you done with those amendments and the responses so that we can take comments from members?
I'm done, and thank you for your comment. We take note of it.
Yes, Chair, we've finished with the presentation now, and we certainly take the comment about trying to ensure everything's correct as possible when we publish the bill and table the bills. We certainly do try to do that, but we certainly bear that in mind. So yes, that concludes our presentation. And now if members have questions, we can certainly have some discussion. Thank you very much, Chair and honorable members.
Okay, Janine and your team, you are welcome. Let's move to item 4. Honorable members, those are the responses and the proposed amendments. Over to you, members. Alan and Tebu will assist me to identify members who would like to speak. For now, I see Dr. George. Over to you, Dr. George.
Thank you, Chair. I'm going to leave my video off because my line is unstable, so let's just hope for the best. I just want to ask one question about the hierarchy of depositors. My understanding is that the concern was that, there should be a hierarchy that specifically pensioners, unemployed people and workers should receive possibly the first bite. But if I'm understanding correctly, is that the way that would be resolved is that the payout would be speeded up. Because if that is not so, I was just wondering how we would identify then the people who were unemployed and pensioners and workers, because it isn't always clear. So I think that's just the one point that I wanted to make. Thanks, Chair.
Okay, thanks, Dr. George. Any other comment or question from members? From my side, I can't see any other member who will want to make a comment or ask a question.
There are no other hands.
No
Other than-
other hands. Okay. Okay. No, it means members are satisfied with the responses, and then also welcome those amendments that are proposed. Let's move to item 5, comments and questions from stakeholders. Stakeholders who made submissions orally and in a written form. It is your opportunity now to make comments or ask clarity-seeking questions. Comrade Matthews, you want to take a lead? Oh yeah, you have already raised your hand. Okay, Comrade Matthews, over to you. Kosato.
Okay. No, thanks very much, Comrade Chair. I think we want to thank colleagues from Treasury for just responding to our issue. So I think, Chair, we had raised the issue of the credit ranking, etc., and I think we appreciate the response from Treasury. I think it does help us quite significantly, because if I understand it correctly, and I think also Dr. George, Honorable George, had raised a similar issue. So when I look at the Treasury response, I think it does help to address our concerns. I think they have said that under the depositor insurance funds, that pensioners, workers, depositors, and banks would be paid within 20 working days. I think that's a reasonable time frame. So I think that's a useful, pragmatic solution to our concern. And I think we also did appreciate that whilst they're not amending the Insolvency Act, because that falls under different departments and so forth, and maybe a separate discussion, that they have pushed up ordinary depositors, which is pensioners, workers, etc., to be third in the ranking queue. So I think on both fronts, it does help our concerns, and I think we appreciate it. And yeah, I think we welcome the bill overall. Thanks, Comrade Chair and members in Treasury.
Okay, thanks, Comrade Matthew, for those comments. Tebuko, I don't see other stakeholders here on my screen who will want to make comments or ask questions. Can you see somebody from your side?
There are no hands from the stakeholders on the platform, sir. So I suppose they are satisfied with what they've heard from National Treasury.
Okay, thanks. Let's go back to National Treasury for responses. Those comments made by Comrade Matthew and also Dr. George. Over to you, Treasurer.
Thank you very much, Honorable Chair. We do certainly appreciate, the comments that have been made, and regarding the speed of payouts, that certainly is noted and appreciated. And I'm sure there would always be an effort to ensure that that payments would be facilitated as urgently as possible. And we would note, this isn't altering really the creditor hierarchy in relation to the Insolvency Act, which is, as noted, does provide some significant protection for employees and their pensions and their other benefits, etc., if there is an insolvency. So would any of the other colleagues, would Lana or Jacques or any other colleagues like to come in on this point?
Janine, perhaps just on the question raised by Dr. George, and I think, again, Hendrik or Sabia can come in and assist me with this, but just to give some clarity. So there's a considerable amount of work that the Corporation for Deposit Insurance has already started with and will be doing once if the bill is adopted and enacted. In terms of information and data, to ensure that they will be able to make that payout. So they will have the details necessary when a resolution is done, when it is a closed resolution, to ensure that those depositors get access to their funds. So there is a lot of work ongoing to identify the depositors.
Okay. Okay. Treasurer, are you done with the responses?
Yes, I think so. Thank you. Unless there are any further follow-up questions that might be asked. Thank you.
Okay. I don't see follow-up responses. It means members and stakeholders are satisfied. Let's move to, before item 7, are there, what do we call them, announcements? Secretariat?
Chair, it's Alan, just from my side. Meeting next week, Tuesday. It's the meeting that was postponed yesterday. That's public hearings on the Fiscal Responsibility Bill. That's Tuesday, and on Wednesday, it is deliberations on this bill that the committee is currently dealing with. Thank you.
Okay. Thanks very much. Thanks, honorable members. As Alan has announced that next week we will be deliberating on this bill and compile a report for the National Assembly and take the process forward. Then that's it. Thanks, Treasury. Thanks, stakeholders. Thanks, parliamentary support team. The meeting is adjourned. Thanks very much.
Thank you very much, Honorable Chair and honorable members. Thank you.
Pleasure.
Chair.
Noxi, kwenzakala yini whip?
Hey, I was whipped by Dorothy today. I was glued in
the
there.
responsibility. I gave Dr. George and Mabileta to whip today because members of DA and ANC who are in the majority and the party were nowhere to be found.
Shame, man, shame. I was logged into the house sitting for the Africa Day debate, and I think I lost count of time, and
Okay.
yes, I'm sorry for that. Shame.
Yeah, we had to call you.
I
because
see
they
that
were
you're
really-
a celebrity these days.
Ubani?
Jojo.
Who's celebrating? Why? Celebrities Zanele from Captain Park. Ethembisa. Mayanga Yanga.
There are celebrities in these rural provinces as well.
Ah, thina sihlalele lapha sijonga inkomo kuphela.
When you are those men, you know those men that they sang about.
Yeah.
That they are rolling stones.
Hayi mina ngihlele lapha emalamulele ngijoga inkomo zami.
Sharp chair.
Jo.
Okay, sure.